Hello, and welcome to today's session. Learning Outcome LO3. Understand the concepts of insolvency and liquidation. Today, we will explore a critical area of company law. What happens when a company can no longer meet its financial obligations? Insolvency and liquidation are central concepts that determine how financially distressed companies are managed, protected, or wound up. This session will guide you through the legal processes, key principles, and practical implications of these procedures. By the end of this lesson, you will understand how insolvency and liquidation operate, the roles of directors and creditors, and the legal framework that governs the resolution of a company's financial difficulties. Insolvency occurs when a company cannot meet its financial obligations. It means either cash flow insolvency or balance sheet insolvency. Cash flow insolvency is when debts can't be paid as they fall due. Balance sheet insolvency is when liabilities exceed assets. Both are governed by the Insolvency Act, 1986. Several factors can lead to insolvency. Poor financial management and excessive borrowing are common causes. Declining sales and rising operational costs also contribute. Economic downturns and market competition can exacerbate the situation. Directors must act responsibly to prevent insolvency from escalating. Directors have legal duties during insolvency. They must act in creditors' best interests, not shareholders. Avoiding wrongful and fraudulent trading is crucial. Maintaining proper records and seeking professional advice is essential. Failure to meet these duties can result in personal liability. Liquidation is the process of winding up a company. It involves selling assets to pay creditors and dissolving the business. Liquidation usually follows insolvency but can be voluntary. Once complete, the company is removed from the Companies House register. It's a formal end to a company's existence. There are three main types of liquidation. Members' voluntary liquidation is for solvent companies. Creditors' voluntary liquidation occurs when a company is insolvent. Compulsory liquidation is initiated by a court order. Each type has its specific processes and implications. The liquidator manages the liquidation process. They collect and sell the company's assets. Settling claims and distributing proceeds to creditors is their duty. Investigating directors' conduct is also part of their role. They ensure the company is formally dissolved. Payments during liquidation follow a legal order. Secured creditors are paid first, followed by insolvency practitioner fees. Preferential creditors, like employees, come next. Unsecured creditors and shareholders are last. Often, unsecured creditors receive little or nothing. Before liquidation, other options may be considered. Administration allows restructuring under an insolvency practitioner. A company voluntary arrangement is an agreement to repay debts over time. Receivership involves a receiver recovering funds for creditors. These alternatives aim to rescue viable businesses. Insolvency and liquidation have significant impacts. The company ceases trading, and directors may face investigations. Employees lose jobs, but may receive redundancy payments. Creditors are paid according to priority, often losing money. Shareholders usually receive nothing unless the company is solvent. A CVA is a legally binding agreement with creditors. It allows debt repayment over time while continuing to trade. Directors remain in control, and it's supervised by an insolvency practitioner. It's a rescue mechanism, not an end. The goal is to return the company to profitability. Setting up a CVA involves several steps. Directors prepare a proposal for debt repayment. An insolvency practitioner reviews and reports on its viability. Creditors and shareholders vote on the proposal. If approved, it becomes legally binding on all unsecured creditors. A CVA offers several benefits. It avoids liquidation, allowing the company to survive. Directors stay in control, and creditor pressure stops. Jobs are protected, and creditors often recover more. It helps preserve the company's reputation. There are challenges with a CVA. It requires creditor approval, and secured creditors aren't bound. The company's credit rating may be affected. Strict compliance is necessary, and ongoing financial pressure remains. Missing payments can lead to termination and possible liquidation. The CVA is governed by the Insolvency Act 1986. It covers how CVAs are proposed, approved, and implemented. The court's role is minimal, intervening only when necessary. Insolvency practitioners ensure compliance and fairness. The process is designed to rescue viable companies. Receivership, administrative receivership, and administration differ. Receivership focuses on creditor recovery. Administration aims to rescue the company. The standalone moratorium provides breathing space for restructuring. Each has unique control, objectives, and outcomes. Winding up involves several stages. A liquidator is appointed to take control. The company ceases trading, and assets are sold. Debts are settled in order of priority. The company is then dissolved and removed from the register. Avoidance provisions protect creditors during insolvency. They reverse improper transactions made before insolvency. Transactions at undervalue and preferences are common targets. The goal is to ensure equal treatment of creditors. Directors must act responsibly to avoid personal liability. Directors face potential liability during insolvency. Wrongful trading occurs when trading continues despite insolvency. Fraudulent trading involves deliberate deceit. Misfeasance relates to misuse of company property. Disqualification can result from misconduct, bearing future directorship. Brighteckold faces insolvency with liabilities exceeding assets. Directors continue trading despite financial distress. Options include CVA, administration, or liquidation. Liquidation seems most viable given the financial position. Directors may face personal liability for wrongful trading. In conclusion, gaining a thorough understanding of these processes is essential for effective corporate management. Should you have any questions, you are welcome to reach me by text or phone on 07000 484 361,688. Thank you for your time, and I look forward to our next session.